We'll be taking our last discussion for today, which has to do with the confirmation of 11 justices of the Supreme Court. Now, Pastor D.G. Olaleye, what do you have to say concerning the newly appointed justices vis-a-vis the court by some even the CJN that appeals terminate at the Court of Appeal? What do you have to say on this?
Well, I'm opposed to it because it will be unconstitutional. The Constitution has stated the journeys of appeal from the High Court to the Supreme Court. And we only know that the Court of Appeal is a final Court of Appeal for election cases, ordinarily. Okay? But to now short-circuit appeals will be wrong. All right? It will be unconstitutional. But I am looking at, well, I want to really appreciate the appointment of the new justices, because this is what we have all been crying out over the years for, particularly in view of the depletion of the number of justices that are sitting and the volumes of appeal that are there. You know, one of my matter, I've just been able to get the year 2027 for an appeal, you know, from the Supreme Court. So, but I believe that with the coming of these new justices, the processes of appeals should be faster than what it used to be. So, kudos to the appointment.
All right, Dr. Yemi, briefly, because we're running out of time. What do you think could be done to ensure that there are speedy completion of appeals at the Supreme Court,
well,
in addition to the appointment of the 11 justices of the Supreme Court?
So the appointment of the 11 justices, which have also been confirmed, is a welcome development for the judiciary, and I say kudos to the brains behind it. I was opportune to appear before some of those justices elevated at the High Court and even at the Court of Appeal. And I can say that they are suitable for the position. Wish them best of luck. They will do the best.
Yeah, but the question is, what will be done? Yes.
Now, you see, appeals...
In a minute.
You see, yes, appeals, some cases, we do respect, some cases or some appeals ought not to get to Supreme Court. You are talking of land dispute in Ikorodu, which is Lagos State. You file the suit, you seek for injunction refuse, you go to court, from court go to Supreme Court. You come back 30 years to come and start the case again. Well, what is this? What is this for that? It's unnecessary. So there are some cases that are supposed to end at the appeal court of appeal.
No,
then some cases that may be of national interest. We do this, some cases that may be of national interest.
Hold on.
May get to Supreme Court. There are some cases that has to do with locality.
We need to do a decision.
What is the business of a Kebbi State land going to Supreme Court?
Hold on. We need to do a distinction between interlocutory appeals and substantive appeals.
No,
are you saying that all appeals should not get to Supreme Court?
No, there are some cases that the appeal should not get to Supreme Court. We do respect.
Cases like which one?
Like land dispute, matrimonial cases.
Land dispute?
Land dispute, matrimonial cases.
End where?
Just hold on. Some land cases should end
where?
If it is land cases that involve federal government, maybe federal government allocation that leads to crisis or dispute, it can get to Supreme Court. But allocation or purchase of land from Omonile landowners still going to Supreme Court.
Where are you recommending it should?
It should end at the Court of Appeal. Then you will see that all these litigants will be very, very happy.
Why?
The cases should be terminated.
Hold on. Why would you want it to get to Court of Appeal but not Supreme Court? Tell us why.
The reason is this.
Yes.
It is local. It is not of national interest. We do research.
Now, Dr. Yemi, are you aware that the Court of Appeal is not a local court, it's not a state court?
No, I'm not saying
I
am not saying the Court of Appeal is a local court.
So what
it's a federal court.
Yes.
Now, but some of those cases, if it ends there, it will reduce the burden of work on the Supreme Court.
The question is not issue of reducing burden of work.
Yes.
How appeals could be speedily dispensed.
Well,
and yet, hold on.
Yes.
And yet not compromise the people's constitutional right to fair hearing.
Now, you see, when we are talking of when we are talking of fair right to fair hearing, this right of fair hearing is with qualifications.
All right.
You can't just say you are denied that as how.
Let us take the talk of
let me say this. If
in a minute,
I think
because we are running up.
Yes, we need to divide what is the objective all right, to be able to develop a policy. I'm against terminating appeals at the Court of Appeal. But nevertheless, if you are talking about speedy trial, speedy process of appeal, I think what we should do is we should have regional Supreme Court. We should expand the Supreme Court as of today. You have several branches or divisions of the Court of Appeal, all of them bringing appeals to one Supreme Court. Why should that be? If you can have branches, if you can have divisions of the Court of Appeal,
that is what the Constitution says.
Yes,
only one Supreme Court. That's what the Constitution says.
That shouldn't be for the whole country.
Thank you very much.
How many judges?
Thank
how
you
many
very
justices? Much. So we should
now,
do that.
What is your takeaway recommendation to the listeners?
Yes.
In 2 seconds.
Yes. What I want to say is that I think we need to overhaul the entire criminal administration of justice process.
Thank
in
you.
the country.
Dr. Yemi, in 2 seconds.
Yes, I say that Nigerians should think deeply before they join issues in respect of issues that doesn't concern them. And
Thank
then
you very
we should
much.
ensure that the country is progressive.